Section 27. Enforcement and penalties when compliance failures become expensive. How big is the fine? Emily's concern about her closing figures turned out to have a reasonable explanation, but her question made Sarah curious. At the next office meeting, Sarah asks her designated broker, if somebody really violates TRID, what's the fine? Her broker smiles. Which violation? Sarah looks confused. TRID. And there's our first lesson. There isn't one simple universal penalty that applies every time someone says TRID violation. TRID integrates disclosure requirements arising primarily under TILA and RESPA. The consequences of noncompliance depend on what requirement was violated, who violated it, the circumstances, the applicable statute, and the available remedies. Stop thinking of TRID as one fine. Agents sometimes hear statements such as, if the closing disclosure is wrong, the lender gets fined X dollars. That's too simplistic. Was the issue a TILA disclosure violation, a RESPA Section 8 kickback, a timing problem, an inaccurate charge, a failure that was later properly cured? Was the conduct intentional? Was the issue something that gives a consumer a private remedy? Is a regulator involved? Different violations can create different consequences. That's why Sarah shouldn't quote a penalty amount to a client based on something she heard in a class 5 years ago. TILA can create civil liability. The Truth in Lending Act contains civil liability provisions for certain violations. Depending on the specific circumstances, available remedies can include actual damages and statutory damages, along with other relief permitted under the statute. But here's the important classroom point. Not every error automatically produces the same recovery. The actual statutory provision and facts matter. Sarah's role is not to tell Emily, you're definitely entitled to $10,000. That's legal advice Sarah isn't qualified to give. She should identify the concern and refer Emily to the appropriate professional when a genuine legal dispute exists. Regulators can become involved too. Private consumer remedies are only part of the picture. Federal consumer financial laws can also be enforced by government authorities. The CFPB has authority to enforce federal consumer financial laws within its jurisdiction and may pursue remedies provided by law when covered persons or service providers violate applicable requirements. Those remedies can potentially include monetary relief, restitution, civil money penalties, or other legal and equitable remedies depending on the violation and proceeding. Again, the important lesson isn't memorizing a giant penalty charge. It's understanding that federal disclosure obligations are real compliance requirements. RESPA can get serious very quickly. Now remember our title company example from Section 20. A title representative offers Sarah $100 for every buyer she refers. Sarah accepts. Now we're no longer talking about a typo on a disclosure. RESPA Section 8 specifically prohibits certain payments or things of value for settlement service referrals. Violations can carry significant civil and, in some circumstances, criminal consequences under federal law. This is why the sentence, everybody does it, is never a compliance defense. A small gift can create a big question. Imagine the title company doesn't hand Sarah cash. Instead, it pays her $3,000 marketing fee. Sarah provides almost no actual marketing services, but she sends every buyer to that company. What would you ask? Was $3,000 reasonably connected to actual goods, facilities, or services? Or was marketing simply the label placed on payment for referrals? Regulators look at substance, not merely what the parties call the arrangement. Changing the name of a payment doesn't automatically change what it is. Now, bring Arizona back into the story. Sarah asks, but if TRID and RESPA are federal, what does ADRE have to do with any of this? Potentially quite a bit, depending on Sarah's conduct. Suppose Sarah knowingly helps conceal a seller payment from the lender, or makes false statements to her client about financing requirements, or participates in an improper compensation arrangement, or ignores material transaction information that she had a duty to address. Even if the underlying mortgage regulation is federal, Sarah's own conduct may raise separate issues under Arizona licensing law and the commissioner's standards. ARS Section 32253 provides grounds for disciplinary action involving various forms of improper licensee conduct. One transaction can create multiple problems. Imagine this scenario. An agent refers every buyer to a particular settlement provider. The provider pays the agent for those referrals. The agent fails to disclose the arrangement. A buyer later complains. Now what do we potentially have? A brokerage supervision issue, an Arizona licensing issue, a consumer trust problem, possibly civil litigation. One bad arrangement can travel through several regulatory systems. That's why compliance should never be reduced to, what's the fine? The better question is, how do we avoid creating the violation? The best compliance strategy is usually boring. Experienced brokers love boring files. Executed documents are there. Amendments were delivered. Emails are professional. Credits are disclosed. Compensation is handled through the brokerage. Questions are referred to the right professionals. Problems are escalated early. Nobody is secretly handing anybody money in a parking lot. Boring is good. Boring closes transactions. Boring protects licenses. What if you discover the error before closing? Suppose Sarah discovers that an amendment was never provided to the lender, and the closing disclosure is therefore using the wrong seller credit. Does she stay quiet because pointing it out could delay closing? Absolutely not. A known problem rarely improves because everyone agrees not to mention it. Sarah should immediately communicate the correct information and allow the lender and settlement professionals to determine what correction is required. A delay can be frustrating. Knowingly closing with inaccurate information can be much worse. What if someone says, "Don't tell the lender"? This should set off every alarm in your head. Imagine the seller tells Sarah, "I'll give Carlos another $8,000 after closing. Don't put it in the contract because the lender might not allow it." Sarah's response should not be, "How are you sending the money?" It should be, "We cannot participate in concealing a material financial arrangement from the lender." Then involve the broker immediately. What would you do? Imagine you're Sarah and a lender employee says, "Don't worry about that disclosure problem. We do it this way all the time." Does that protect you? No, Sarah doesn't need to supervise the lender. But if she knows transaction information is inaccurate or is being concealed, she should not knowingly participate simply because another professional says it's normal. When something feels wrong, document the concern and involve your broker. Broker tip: don't practice penalty trivia. Your clients don't need you to memorize every federal penalty. They need you to recognize risk. If someone asks, "What is the exact penalty for this?" and you don't know, don't invent one. Say, "The consequences depend on the specific law and facts. Let's get the appropriate professional involved." That's more accurate and much safer. Sarah now understands that compliance isn't about memorizing scary fines. It's about preventing the conduct that creates them. But there's another protection that becomes incredibly important once something goes wrong: the transaction file. In the next section, we're going to look at record keeping, emails, text messages, amendments, disclosure records, and what happens when an investigator asks, "Show me what happened." Online discussion. 1. A client asks Sarah, "What is the automatic fine for a TRID violation?" Why should Sarah avoid giving one universal number? Answer: TRID requirements arise from underlying federal statutes and regulations, and consequences depend on the specific requirement violated, the party responsible, the facts, available statutory remedies, and any applicable enforcement authority. There is not one universal penalty that applies to every possible TRID error. Sarah should avoid providing unsupported legal conclusions or promising a particular recovery. 2. Sarah discovers before closing that the lender has an outdated amendment and the closing disclosure reflects the wrong seller credit. Should she remain silent to avoid delaying closing? Answer: no. Sarah should promptly provide the correct transaction information to the appropriate lender and settlement professionals and allow them to determine what correction is required. Knowingly allowing the transaction to proceed using information Sarah knows is inaccurate could create greater risk for the client, agent, and brokerage. 3. Why could participation in a prohibited settlement service referral arrangement create both federal and Arizona concerns? Answer: a referral arrangement involving a prohibited thing of value may implicate RESPA Section 8 at the federal level. If an Arizona licensee knowingly participates in improper conduct, makes misrepresentations, or violates professional duties, the same facts may also create licensing concerns under Arizona law and the Commissioner's standards.